From the past 2 months, Manipur state is in news for all the wrong reasons, and the last video which went viral shows the horrific incidents towards women, in which 2 Kuki women were stripped, raped and paraded naked in the streets of Manipur by all the 𝐈𝐀𝐒 men. And this poses a serious question on the state government, also on the central government, that what these governments are doing to protect the dignity for the women. Hello everyone, welcome to the new series of Drishti IAS. I am Ritu and today we are going to discuss an important topic. The title of today's topic is Manipur video has been asked to take down under section 69A, and this topic is important from GS2 perspective. Moving to the next slide, which is previous day practice question. So in this question, which of the following components are not part of universal basic income? So this is not part of universal basic income. Here it comes periodic. Moving to the next slide. So the slide is about, first of all we will discuss the news. What is section 69A of the IT Act? What has the Supreme Court said on the section 69A? How did Karnataka HC rule on this? Practice question for prelims and mains. Moving to the news part. So we already know that a horrific incident took place in Manipur which has shook entire nation, and after this incident the center has asked all the online platforms to take down the videos under IT Act 2000 in section 69A. So this is the news. Moving to the next slide. What is the section 69A of the IT Act? So section 69A of the IT Act allows the government to issue content blocking orders to all the online platform. It means internet service providers, telecom service providers, web hosting services, search engines, online marketplaces. And when it does exercise and when the central government decides to implement this section, so when there is a harm on national dignity or national sovereignty or dignity of any women, any community or any tribe, so the central government can ask all the online platforms to take down the video or all the contents which are related to that incident. So moving to the next slide. What has the Supreme Court said on the section 69A? So there was a landmark judgment of Supreme Court in 2015 and the name of the judgment was Shreya Singhal versus Union of India. In that judgment, Supreme Court has struck down the section 66A of the Information Technology Act 2000, and the petitioner also asked to take down the section 69, but the Supreme Court has said that section 69 is very constitutionally valid, so this could not be struck down, but section 66A was struck down. And why it was struck down? Because there was a term used for the offensive. So this term is very vague in nature, and so many courts, so many police officials interpret it in a very different way, and so many social media platforms also interpret in a different way. So this creates lots of controversy. Because of this 66A was struck down by the Supreme Court. Moving to the next slide. So there is a difference between section 66A and section 69. So section 69 was narrowly interpreted, and because there are 3 reasons for this. The first reason is that blocking can only be restored in where the central government is satisfied that it is necessary to do so. It means that here the consent and the priority of the central government is very important. So central government can decide that it is necessary to take down all the videos or it is necessary to block the content. So it's all depend on the central government. The second reason is that such necessity is relatable to Article 19(2). So in the comment section you have to tell that what is Article 19(2). And the third is regions have to record it in writing in such blocking orders so that they may be assailed in a writ petition under Article 226 of the Constitution. So Article 226, under it you can go to directly High Court for the violation of your fundamental right. So these are the reasons. Moving to the next slide. How did the Karnataka HC rule on this? So last year this thing was also in news, and section 69 was again under the legal scrutiny in July. And after that, and why it was in news? Because the Twitter official has alleged that Ministry of Electronics and Information Technology is misusing its power and they are blocking the contents on Twitter and other social media platforms. But Karnataka High Court has ruled that it's very necessary for the central government and the ministry to take down all the contents, and they have right to do so, because if they will not do so, it will create disharmony between the society and it will create hindrance in the democratic process of this country. So this is very important, and the Karnataka High Court has also said that, they have not just right to take down the tweet, they have also right to block the whole account also. So this is the judgment by the Karnataka High Court. Moving to the next slide. So practice question for prelims. Consider the following statement regarding section 66A of Information Technology Act. So you may wonder that why this question is related to section 66A, because it has been already struck down. Because after the striking down of this section, so many police officials, so many judges, so many lawyers are also using this, and under it so many cases are registered. So because of this thing is very relevant, and Supreme Court had also asked all the judges, all the lawyers and all the police officials to not to use this case and not register any cases related to it. So that's why this section is very relevant. So your first statement is, it made a punishable offense for any person to send offensive information using a computer or any other electronic devices. Second is, it had prescribed 5 years imprisonment. So which of these statements given above are correct? So your options are 1 only, 2 only, both 1 and 2, neither 1 nor 2. Moving to the mains part. Practice question for mains. So your question is, the freedom of speech on the internet is a fundamental right. However, it should not be absolute in nature. Comment. So first of all, you have to find the keyword here. So here keyword is freedom of speech. So in intro part, you have to briefly define that what is the freedom of speech. Here you can also quote Article 19 and all the 6 freedoms it has given under Article 19. So in this way your intro would be good. Coming to the body part. So here they are asking that internet is fundamental right. However, it should not be absolute in nature. So in body you have to justify your answer that how internet is a fundamental right, because through internet we can access our freedom of speech and expression, we can enjoy, we can show our talent. So it's totally a fundamental right, and in today's world social media is serving as a employment opportunity for many people. So it is directly related to the fundamental right. But there is a problem and there is a loopholes in this, because in the garb of freedom of speech so many people does unethical activities which is very harmful for the country, harmful for the dignity of the women, harmful for the dignity of the lower caste and scheduled tribes. So in that case central government has all right to take down all the tweets, take down all the posts which are heinous in nature, which are very harmful for the society. So they have all the rights. So in this sense you have to justify your answer, and in the conclusion you have to also write that many times central government also misuse their power and so many tweets are taken because of the political rivalry. And you can also discuss the recent Twitter CEO case. The ex-Twitter has alleged that during the farmers protest central government has deliberately asked to take down so many tweets and close so many Twitter accounts. So these kind of options and these kinds of example you can use in your conclusion part. I hope you like this lecture. If you have any queries related to this lecture, kindly ask in the comment section. Thank you.